All right, grade 11s, it's time to talk about defenses to crime. You've learned about what constitutes a criminal act. You've learned about some of the different offenses listed in the criminal code. What happens if you get charged and you want to plead not guilty? Well, let's talk about the different options that are available. So a defense is by definition either a denial or a justification for criminal behavior. So it can either be a full out denial, I didn't do it, or it can be a justification, I did it, but there's a reason. So before I go any further, let's pause for a second here and think of how many defenses you can name off the top of your head. There's 15 in total. Take a second and count them out. If somebody's charged with assault or somebody's charged with murder, what kind of defenses can they use? If you made it to 10, I'm super impressed. All right, let's dive in and find out what some of them are. So as I said, there's three main categories. First is the defensive mental state. Second is justifications, and then there's sort of a miscellaneous category. We're going to look at mental states first. So the first word I want to introduce you to is automatism, not to be confused with autism. That's different. Think of automatism as like automatic, somebody acting, physically carrying out an action, but without really being aware of what their body is doing. If their body is doing something, but their mind is not deliberately engaged in that act, then mens rea isn't really present, is it? If the action isn't voluntary, then you can't prove the second element necessary to prove somebody guilty of a crime. You have the physical action, but you don't have the mental action. Let's look at where that takes place. So there's two types. There's insane automatism and non-insane automatism. So insane automatism is what it sounds like. So it's where somebody is physically engaged in some sort of physical action, but they have a severe mental disorder like bipolar disorder, schizophrenia, delusional post-traumatic stress disorder, something like that. There's also a category called non-insane automatism, and it includes an unusual list of things. So we'll look at the defense of sleepwalking. If you know people who talk in their sleep or who get up and move around in their sleep, it may not surprise you to know that some people commit actions that would be classified as criminal while they're sleepwalking. Something like epilepsy or Tourette's can force somebody to have physical convulsions that might lead them to come into contact physically with somebody else in what would normally be classified as an assault. But obviously, you're not going to blame somebody who's having an epileptic seizure for slapping someone in the middle of it. They're not conscious of what they're doing. If you or anyone you know has ever had a concussion, you know that it can have serious impacts on people's well-being and their awareness of what they're doing. Likewise, diabetes, whether it's high blood sugar or low blood sugar, can radically change someone's behavior. And I know the last one on this list is going to strike you as funny, but an attack by a swarm of bees. Let's say you're driving down a country road. It's a beautiful day. You've got the windows open. You're passing a farm. You're looking at the cows and the horses. And you're saying, oh my God, look at the horses. They're so cute. And all of a sudden, a swarm of bees flies in your window, causing you to let go of the steering wheel, flap your hands madly. Maybe you slap the passenger in the seat beside you, and then the vehicle crashes off the road, and you're charged with something like reckless operation of a motor vehicle. Well, your defense would be non-insane automatism. Yes, your body was moving, but you were reacting to something, and of course you didn't want to hit your friend, and of course you didn't want to crash your car. So, hope that's helpful. I want to talk about a very unusual case. RV Parks, it's in your textbook. I can't remember what page it's on, but somewhere in this chapter. And it was an incredibly controversial case at the time because Ken Parks was charged with the first-degree murder of his mother-in-law. He stabbed her repeatedly with a kitchen knife and also attacked his father-in-law. And then, so the story, the full story is he fell asleep watching TV, got up, got into his car, drove several kilometers to his in-laws' place, got a kitchen knife, killed his mother-in-law, hurt his father-in-law, got back into the car, then drove to the police station. And as he was waking up, he was standing in front of a police officer covered in blood saying, "I'm not sure what's just happened, but I think I might have killed someone." So this case really strained the imagination of a lot of Canadians. Some people who experienced sleepwalking believed him and thought, you know what, it is entirely possible. Some people were convinced he was making it up. The court found that he was not making it up, and they relied heavily on expert testimony that showed that Parks had a history of sleepwalking going back to when he was a child. But I would ask you to consider, what's more scary? The idea that he was lying about sleepwalking and got away with it, or the idea that he was telling the truth? Can you imagine waking up and having no recollection of doing something like that? It was a fascinating and disturbing case. Let's talk now about the defense of mental disorder. There's a section in the criminal code that defines mental disorder. In order for it to succeed, and please, let's put aside the very real stereotypes that it's easy to fake being crazy. It's actually really not. The testing for it in a criminal case is quite rigorous. So the defendant has to prove that at the time of the offense, they were suffering from a mental disorder. The presumption in this case is that they were not suffering from a mental disorder, and so the burden shifts to the accused person to prove the contrary. Now, they don't have, obviously, it's hard to prove beyond a reasonable doubt, so the burden is a bit different. It's the same as in a civil case, and the concept is a balance of probabilities. So you simply have to convince the jury that you were more likely than not suffering from a mental disorder. There's also the issue, though, that an accused has to be fit to stand trial, and not fit in a physical sense, but in a mental sense. And if I'd been able to take you to the courts this year, and if we'd been able to go to mental health court, often you can see a fitness assessment taking place. And it's just a series of questions where the judge asks the accused, "Hey, do you know where you are? Do you know what year it is? Do you know what my job is? This person over here, the Crown Attorney, do you know what their job is? Do you know what you're charged with? Do you understand what'll happen if you're found guilty?" An accused has to be able to answer all of those questions in order to be fit to stand trial. If they're not, they'll be ordered into the hospital for treatment in an effort to get them fit to stand trial. So I've got some speaker's notes here that I want you to take a look at. One of them is this whole business about being fit to stand trial. The other is, I want to encourage you to learn about different mental illnesses. Bipolar disorder, delusional disorder, schizophrenia is perhaps the least understood. And my suggestion to you is that really you should, take a course like ASP or take psychology in post-secondary and do some serious academic research to learn about schizophrenia. But I will tell you that I've been learning a surprising amount lately by following a schizophrenic on TikTok, of all places. His name is Cody Green, and he goes by the handle Schizophrenic Hippie. And he talks openly about what it's like living with schizophrenia, what his hallucinations feel like. And he's doing, I think, a great job of raising awareness about what it's like for him to live with this disorder. So obviously, more academic research would be better, but if you're on TikTok, you should check him out. I really believe in trying as often as possible to learn from people with real lived experience. So let's dive in a little bit deeper. In order for the defense of mental disorder to succeed, you have to prove one of the two following things. So you either prove that the mental disorder left the accused incapable of appreciating the nature and quality of the act. So at the time they were, say, killing someone, they didn't understand that what they were doing was actually going to hurt someone or kill them. That maybe in the process of their delusion or their hallucination, they believed that they were freeing that person's soul or they were saving them from the devil. That they genuinely didn't understand what it was that they were doing and the long-term consequences. The other side is that sometimes a mental disorder can render the accused fully capable of knowing what they're doing, but simply not understanding that what they were doing was wrong. So they may be completely clear about the fact that they are killing somebody, but they are under a delusion that this person is the devil. And so they think they've been told by God, for instance, that they must kill this person in order to save the world. And so they don't think they're doing anything wrong. They think they're doing something right. Both of these scenarios are tragic and unfortunate and not something to be laughed at. So what happens if somebody successfully raises the defense of insane automatism? Well, we have a policy in this country that if somebody is guilty of a crime, if they had the mens rea and the actus reus, they go to prison. But if they're found not criminally responsible, well, we don't send them to prison. We send their case to a place called the Criminal Code Review Board. And once there are three options that can be considered. A rare one is an absolute discharge. So if the person is found to have suffered a singular episode, and expert psychiatrists and psychologists feel that it's unlikely to ever happen again, and the person is a low risk to society, this would be used. A conditional discharge might be a situation where the accused is released, but they have to check in on a regular basis with a therapist or with a psychiatrist to deal with medication issues, right? That's the main difference, if you didn't know, by the way, between a psychiatrist and a psychologist. A psychiatrist will do some talk therapy, but mostly works with the medical side of mental disorders and prescribes medication. A psychologist can't prescribe medication, but can engage in talk therapy. The third option, if somebody's found not criminally responsible, is that they can be sentenced isn't the right word, but they can be committed to a psychiatric hospital for up to 90 days. And then it can be reviewed every 90 days after that. The intention of sending somebody to a psychiatric hospital is for them to get better. And one of the things that irritates me when I see cases in the headlines is that the journalists and the public don't seem to have a very clear understanding that if somebody commits an offense while suffering from a mental disorder and then they go to a hospital and they get better, well, then we shouldn't be keeping them in that hospital. This becomes really troubling, though, when you get into specific cases. And I'll put a content warning here. This case is gruesome, so if you want, skip to the next slide. But this is the case of, what was his first name? Lee. This was a particularly awful case. This man had a history and got onto a Greyhound bus and had a major psychotic break and believed that the people on the bus were agents of the devil and had to be killed. And he killed them in just absolutely vicious manner. And the attack went on for a long time. The bus was surrounded. The police had trouble getting onto the bus. And many of the officers that attended actually had to be treated for post-traumatic stress disorder because he was doing horrible things to the bodies of those that he killed. So he was charged and he was found not criminally responsible. But as I said, when he was found NCR, the public kind of went wild and went, wow, how is he getting away with not going to prison? How is he getting away with just going to a hospital? It's like, well, If he's sick mentally, then he needs to be in a hospital. We put people in jail if they are people that intentionally committed an action, not unintentionally. Anyway, we could go on about this at length. Let's switch gears for a little bit and talk about the defense of intoxication. That's just a sip of Diet Coke I took, I promise. So, you know what intoxication is. Generally, it's not a valid defense to a crime. But I've often thought that an excellent detention to give to a kid who showed up drunk or high to class would be to make them go through our textbook and count the number of cases of criminal actions where alcohol or drugs were a factor. Because I'll tell you, it's a lot of them. When the defense of intoxication is raised, it's not meant to excuse the action. Sometimes it's raised to try to reduce the severity of the offense, and I'll talk more about that later. So it can be raised as defense, but only in cases of specific intent offenses. So this goes back to reviewing something that we learned in a previous chapter. So a specific intent offense occurs when a person commits one wrongful act for the sake of accomplishing another. So you break and enter in order to steal, to commit theft. But it is not a valid defense if the person is committing a single act for its own sake, for instance, an assault. A defense of intoxication hardly ever results in an acquittal. Instead, what you will see sometimes is that the charges may be dropped one level. So if somebody committed a robbery while they were drunk, maybe the charge will be dropped to assault. Or if they're charged with second-degree murder, they might drop it down to manslaughter. The other option is if there's multiple offenses involved, a jury may decide to acquit on one offense, but convict on the other. And it should go without saying, but just in case, no, intoxication is never a defense to an impaired driving charge. I want to tell you, and again, there's a content warning on this, and we're going to talk about sexual assault here. Really disturbing and controversial case in 1994, where, and this was an older, both defendant and accused person. They were both in their 60s, I recall, and the woman was in a wheelchair. And they drank together quite frequently. And one night, they got incredibly drunk. And the accused said that he got so drunk that he didn't remember anything that happened, and therefore he should be allowed to use the defense of mental disorder because he was incapable of forming any intent to commit the sexual assault at all. Shockingly, the Supreme Court agreed with him, and you have to go read the case to really understand, but they had to look at common law and the history of the defense of intoxication. And there was a gap that existed in the Canadian Criminal Code that meant that the Supreme Court had no choice but to find him not guilty. So they did find that he voluntarily became intoxicated, but that they couldn't find a reason in Canadian law to convict him of the offense. Well, the response to this case was swift and instant. I was in university at the time, and I remember thinking, this is terrifying because to a lot of women, it sounded as though, well, women and men that are victims of sexual assault, it sounded as though all that an attacker had to do was say that they were blotto drunk and then they could get away with sexual assault. And that's not okay. So there were a ton of protests, a lot of discussion in the media, art exhibits like this one. And then finally, Parliament responded and they closed the loophole that had been created by the decision. And I'll show you the section of the criminal code that's now in place to deal with this. this is quite long, but what it basically says is um, you cannot use self induced intoxication if you are charged with an offense that involves interfering with the bodily integrity of another person. So, what offenses deal with bodily integrity? Well, assault or sexual assault. So, that is what the law now says. So, no, you can't use intoxication as a defense to assault or sexual assault. And that is as it should be. Let me just let that load. All right, we're going to switch gears now and talk about justifications. So these aren't defenses, these are situations where you say, yes, I did the thing, but there's a reason and I want you to hear it. So first, you may have, back in the brainstorming session, thought of the defense of self-defense. So if somebody attacks you, you're allowed to defend yourself. Well, the law says, yes, that's true, but you have to be careful about how hard you fight back. So you're justified in repelling force by force if the force that you use is not intended to cause death and is no more than is necessary to enable you to defend yourself. Well, that becomes a little bit tricky. So the force used must be reasonable. So the answer to any question that you may ask saying, okay, so somebody came after me with a stick and then I took out a knife, is that justified? And the answer is, it depends. It will all come down to what the judge or the jury decides is reasonable in the circumstances in that particular case. Generally speaking, though, there's a sort of common law concept called the +1 rule, that says you're allowed to repel force by going sort of one level above the violence that's being used against you. So if somebody, somebody slaps you, you may repeatedly, you may respond by punching. But no fair if somebody comes at you with a knife and you reach into your back pocket and pull out an AK-47 and blow them into next year. That's not a +1, and that's not reasonable in the circumstances. So, can you get away with killing somebody in self-defense? Yes, you can. There are cases where this has happened. It really, again, depends on the circumstances. You have to be able, like, you will be charged with killing somebody, whether that's first or second or manslaughter. You'll be charged, you'll offer the defense of self-defense, and then you have to prove that during the attack, you were under a reasonable apprehension of death or grievous bodily harm. That you were, that you had been so badly assaulted, you honestly thought you were going to die, and you had no option except to do what you had to do to defend your life. So, are there situations that happen like that? Yes, there are. They're rare, but they happen. Oh boy, so many warnings in this, but I'm going to talk about domestic violence for a second, because there is also a rare defense. It hasn't been used a lot, but it has been recognized by the Supreme Court of Canada, that often when a woman, or it's also, I think, been recognized in relation to children, when somebody is repeatedly assaulted over an extended period of time, it affects, obviously, the person's state of mind. It will often lead for a person to become hypervigilant. And so, their attacker's eyebrows twitching can suddenly put the person into a really, really high state of anxiety. It can cause them to misread how much danger they're in. It can cause them to underreact. It can cause them to overreact. But there are cases, and really, if you don't know much about domestic violence, please take my word for it as somebody who grew up in a household where it was a factor. It is incredibly isolating for victims, because often it isn't just, sorry, this is very blurry, it isn't just the violent episode, but then there'll be an absence, there'll be an apology, there'll be groveling, and then there'll be a building of tension, and then it will escalate, and then it happens again and again and again and again. There's also often financial isolation that takes place. So the controlling partner will often take control of the family finances. Children are often used as weapons. You know, if you report me, I'll hurt the kids, or I'll take the kids, that type of stuff. So in some extreme cases, when a woman, usually in this, well, we're talking about battered women syndrome, when this has gone on for a long time, and a woman kills her partner, again, it's not a defense, but it's an explanation that can be used to reduce the sentence. The precedent-setting case in this regard was R.V. Lavallee. This was a woman who had been beaten so severely she'd been hospitalized multiple times. She was attacked on the night that she killed her husband. He attacked her. He left and said as he was leaving that when he came back, he was going to kill her. And then as he was leaving, she shot him in the back of the head. The fact that it was in the back of the head that he had turned to leave was really sensationalized in the media. But the expert testimony showed the long-term impact that living with domestic violence had on the accused. And so it was, she wasn't acquitted, but the defense was taken into consideration at her sentencing hearing. All right, something a little less triggering. We can talk about defensive dwelling. I think I've mentioned before that there's really a common law principle that, you know, your house is your castle, your kingdom. It's the place where you're supposed to be safe. And so the law does recognize that you are allowed to take steps, necessary steps in order to protect your house or to remove a trespasser. That if somebody comes onto your property and you ask them to leave and they don't, you can call the cops and say, hey, there's a trespasser. Now, this isn't America. You can't shoot somebody for coming onto your property. That's not okay. And if you do have to use force to remove somebody from your property, then again, the force must be reasonable. You cannot throw them headfirst through this glass window out onto the driveway. You can, however, push them off the driveway and onto the sidewalk. Next up, we'll talk about the defense of necessity. Now, how could a crime possibly be necessary? We're not talking about major offenses here like kidnapping or terrorism. We're talking more about like motor vehicle offenses. So say I'm driving and I'm coming to an intersection at Hurontario and Dundas, and I see that the light is changing, but I also see that I've got a car that's very, very close to my back bumper. And I know that if I slam on the brakes, I'm going to cause an accident. I look ahead into the intersection. I see no one's coming in it, and I run the red light. Well, technically, I've committed an illegal act, and I can get pulled over. But I could offer the defense of necessity. Now, it's not as simple as saying, but I needed to run the red light. You actually have to prove a few things. So first you have to prove that the act was done to avoid a greater harm. So I was trying to avoid an accident with the vehicle behind me. Second thing is that you have to prove that there was no reasonable opportunity for any alternative course of action that wouldn't have also involved a breach of the law. So I couldn't have changed lanes because there were cars on either side of me. There was nothing else I could do. And here's the kicker. You have to prove that the harm inflicted was less than the harm avoided. So how much harm did I inflict on others by running the red light? I may have startled a few people, but I didn't harm them. But what's the harm that I avoided? A major collision with the vehicle behind me. Let's talk next about compulsion, or also it's frequently referred to as the defense of duress. Somebody is under duress when they are prevented from acting the way that they would choose to do so because their free will is being manipulated by somebody who is threatening them, threatening to hurt them or threatening to hurt someone that they love. So if I get into a taxi and I put a gun to the head of the taxi driver and say, drive fast now, and that taxi driver, gets pulled over for speeding, well, first of all, I'm in a lot of trouble. But secondly, the taxi driver can say they're not guilty by reason of duress. That yes, they did it, but they can't be held responsible. Now, the law on compulsion is really controversial, and if you want to read a fascinating case, look and please don't be skipping the cases when you're reading the textbook, but check out R.V. Ruzick. In this case, the accused was asked to smuggle drugs across the Atlantic Ocean, like by taking an airplane. But the person who was forcing her to do this was threatening, I think, to hurt her mother back in her home country. And she wanted to offer the defense of duress, but the criminal code says that the person doing the threatening has to be physically present when the offense is committed. Well, of course, the person was back in Europe. And then the other thing is that the threat has to be immediate. In this case, there wasn't a set date when the harm was going to happen. It was just a vague sort of threat. So these sections of the criminal code were actually struck down in 2007. And I have not been able to find out with my own research what's happened, whether they've been replaced since. I got into the criminal code and I can still find section 17 there. But I don't know what's happened to it. So this has been struck down, but I don't know if it's been removed from the criminal code or replaced or what just yet. Anyhow, let's move on to one of the last few defenses. There's the defense of provocation. So this is when somebody says words or commits actions that are so insulting and so inflammatory that an ordinary, reasonable person would lose self-control. In some cultures, this is easily accomplished by insulting someone's mother. You do that, you're getting punched. Now, the defense of provocation doesn't really work in an assault case. It only applies to the defense of murder, and to the charge of murder, and it doesn't help you get away with murder. All it does is reduce the charge from murder to manslaughter. Now, some countries have abolished this defense, and there have been some controversial cases where people have tried to use their own homophobia as part of their provocation defense. Like, oh yeah, so this person was coming on to me, but I'm straight, and that provoked me so much I had to kill them. And there are many states and jurisdictions where that kind of defense has been completely outlawed because, no, you're not. You're not suffering from a phobia. You're just a bigot. Sorry, personal commentary there. If you're going to try to plead provocation, check this out. You have to prove all four things. So first, a wrongful act or insult occurred. Second, that it was sufficient to deprive an ordinary person of the power of self-control. You want to know whether an ordinary person would lose control? Ask a jury. 12 reasonable people will tell you. The response has to be sudden. You can't go home, stew about it for a while, and then go attack the person. So they have to respond before there was time for passion to cool. Hang on. Hydration break. Oh, thank goodness for Diet Coke. All right. We're going to talk about Aboriginal treaty rights, and these are really, really relevant, especially as we look at some of the conflicts that are happening around pipelines, because some of the cases that I'm going to talk to you about actually establish precedents that are relevant to that. So although treaty rights really only come into play when we're talking about hunting and fishing rights, the impact of Section 35 of the Constitution has actually been a little bit larger than that. So the purpose of Section 35 was to recognize that Indigenous people were here first, and that fact alone grants them certain rights, particularly when it comes to the land. In the case of R.V. Sparrow, and it's not a bird case, it's actually a fish case, a gentleman named Sparrow was accused of fishing with a net that was longer than was what is allowed under the Fisheries Act. He admitted, yes, his net was too big, but he said he had an Aboriginal right to fish for food. In his area, there was more and more commercial fishery taking place, and the law at the time said that he was only allowed to fish for his own food. And actually, I'm going to throw you over to this site at the University of British Columbia, and it's got a really good explanation of the history of the Sparrow case, what happened, which band was involved. And the significant part is down here. The Supreme Court, because this was a precedent-setting case, they'd never really been asked to decide anything like this, they set down some terms that would apply to all future cases. So first of all, you can see there's a three-part test to find out whether an Aboriginal right has been infringed upon. And then second, if the government is going to try to justify an infringement of an Aboriginal right, then they have to do these four things. And look at this last one. Aboriginal groups were consulted or at least informed. Think about the implications that that has on things like the XL pipeline, for instance, or the Keystone pipeline. Is it enough to be informed? Is it enough to be consulted? Was the consultation meaningful, or were they simply going through the motions? So that's a big issue. Another case, and I think one of you may have written a case brief about this, is the case of R.V. Vanderpeet. And this is another one, this time I think involving a woman who was fishing. And the details of the fishing part are actually, I mean, they're important, but the real important part here is that this case sets down a test that outlines when Aboriginal rights are really engaged. So if you're going to try to prove that, well, you have an Aboriginal right to do something, how do you prove that? Well, the first thing is you have to establish that the thing that you're doing, whether it's fishing or a powwow or a potlatch ceremony or anything like that, you have to prove that it was a practice or a tradition that was a central and significant part of Aboriginal society. But more than that, you have to prove that it existed prior to contact with European settlers. So, you know, as much as I love the band A Tribe Called Red, they can't claim an Aboriginal right to mix powwow music with club beats because that wasn't a thing prior to contact. Very, very cool band, though. DJ, check them out. The other thing that has to be established is that the activity was one that continued to exist after 1982, which is when the Constitution Act was passed. Now, it's okay if the activity changed over time. So powwows have changed, and potlatch or gift-giving ceremonies have changed over time. That's okay, but they have to have continued to exist after 1982. Now, you would be right if you wanted to question whether or not Canadian policies that favored the assimilation of First Nations people managed to extinguish certain cultural practices and traditions by 1982 through the use of things like residential schools. You would be absolutely right to question those things. P.S. Aboriginal law is a fascinating field and we need more people in it. Totally different topic. There is also the defense of officially induced error. So let's say you're on one of those streets in downtown Toronto that appears to have, as you pull over and park your car, about 14 different parking signs. One of them says that you're allowed to park here between 11 and 8. Another one says you can only park here Monday to Fridays. There's another sign that seems to be telling you you can only park there on Wednesdays if it's sunny. You cannot tell. And at that moment, a police officer happens to be walking by and you say, hey, officer, all these signs are confusing. Can I park here? Or fish or hunt or drive or whatever. If that official says yes, and you are like, hey, I did my due diligence. I went and I asked for advice and they told me it was okay. And then later you get punished for doing exactly that thing that you got permission to do, you can plead officially induced error. So you have to be able to call that person to the stand and say, hey, do you remember when I asked you if it was okay and you said it was okay? Well, now I'm here because they're saying it's not okay. All right. Mistake of fact. So here's a crazy scenario. Um, and it happens way more often than you think. I've had the situation where I've parked my car in a large parking lot at a mall, and I come back to the area where I'm pretty sure I put it, and I go up to the car and I put my key in the lock or I press the button, and then I look inside the car and I realize, oh, wait a second, this one isn't actually mine. I've had this happen. Like now my kids are older. There was once I went up to a car um, and the lock wouldn't open. I was really, really frustrated until I saw the car seat in the back. And then I was like, oh, yeah, I don't have babies anymore. They're all grown up. But there are some cases where two people have a key that will open two totally separate cars. And it has happened where somebody gets into a car, starts driving, and they don't realize for a long time that it's not their vehicle because it's the same year, the same color, the same make. So mistake of fact only works in a situation like that. If it's an absolutely honest mistake, and if what the accused believed had been true, then there would be no offense. So that's a funny one. Hey, have you heard of double jeopardy? It's not just a special type of question on the show. It's also the important and legal doctrine that an accused person can't be tried for the same offense twice. And this really speaks a lot to just how much of a burden is placed on the Crown when they're prosecuting somebody for a crime. So, if they're investigating somebody for a serious assault or a murder or something like that, they have to get all of their evidence in place and really be sure that they've got enough to bring to a judge or a judge and a jury and get a conviction. And in fact, they won't lay charges until they're confident that they've got enough evidence or they're very, very close to having enough evidence to guarantee a conviction at trial. Because here's the thing, if they go to trial too soon and they don't have all of the evidence they need, and the person is found not guilty, and then a week later, a major piece of physical evidence shows up, or a witness finally comes forward that wasn't willing to speak before, the Crown cannot recharge the person. There are no do-overs for the state or for the Crown. So if I'll use myself as an example. If I kill someone named Frank in 2007, and I go to trial in 2008 and I'm found not guilty, and then in 2009, someone comes forward and says, oh my God, I was there. I've been keeping quiet all this time. You know what? Too late. They can't bring me back and charge me again. There's an excellent movie by this name, by the way, that you should check out. I'm pretty sure most of you have heard of the defense of alibi. This is where you can say to somebody, no, I didn't do it. I wasn't there. I was over here. And I can prove to you that I was over here because this person was with me. And they will testify saying, I wasn't at that location. I was with them at the time the crime was committed. So it relies on the testimony of a witness. The burden here is on the Crown, not the accused. So if I bring forward an alibi and that alibi says, yep, I was with her, and the Crown doesn't believe them, well, they have to undo the validity of that testimony. Something that can be raised as a defense is entrapment. Often police will do undercover work, but if they conduct an undercover activity, for instance, you can check out undercover cop movies like this one, they can present a suspect with an opportunity to commit a crime, but they can't harass or bribe or threaten the person into breaking the law and then go, ha ha, I'm a cop, you're busted. All they can do is set up the conditions necessary for the person to possibly choose to commit an illegal act, but they can't threaten them into doing it. A huge controversy in Canadian law that's gone on for years involves a technique developed by the RCMP that has now been found to be illegal by the Supreme Court. But it was a system of entrapment called the Mr. B tech, or the Mr. Big technique, rather. And what they would do, and this applied in the case of R.V. Burns, is they would set up a situation where an accused had done something illegal, and they were suddenly introduced to people from criminal organizations like the mafia or different gangs. And they were asked to prove themselves worthy of being in this gang by committing some minor illegal acts, and then eventually introduced to like the big head boss. And then the boss, who was actually an undercover RCMP officer, would tell them, you need to prove to me that you're the kind of person that I can rely on. So, I've heard that you did this thing, but you need to tell me all of the details of what you did right now, or else we're not going any further. And then the person confesses to what they did, and then boom, they're placed under arrest. The psychological manipulation involved in that technique has been so controversial that, as I said, the Supreme Court simply struck it down. So this brings us to the end. A couple of cartoons for you. Your next step after listening to this, and of course also reading the textbook, don't forget to read the cases, is to complete the organizer called Defenses Applying the Law. Here's a little cartoon about the defense of provocation. You don't want to provoke a German Shepherd. That's never a good idea. And here's a little bird mafia cartoon for you. Anyways, that's all about defenses. Hope you learned something, and I'll see you next time.